and this of the webinar we carry out every month for the recent judgment, both uh, of NCLT and NCLT Supreme Court, and also the Disciplinary Committee. So the intention here is to update, because IBC code amendment is, for God's sake, is reduced a little bit. But yes, of course, all IPs and lawyers and everyone is expected to be updated with the case laws, and that is a bigger challenge. So we try to give everything in a very crisp manner so that we are updated with the recent updates. And welcome, Mr. Ayush, for your time. Welcome all the friends and participants. And we request, if you have any question, answer, or any query, you can, raise the hand and you can speak it. Mr. Ayush is a managing partner of his firm AKR Legal. He has over 16 years of professional experience, which expands to insolvency and bankruptcy code, transfer pricing, international tax. He was previously associated with Deloitte for a period of over 7 years in his initial professional days before setting up his own practice. He is a fellow member of ICAI, Chartered Accountant, and a member of Bar Council of Maharashtra and Goa, and also holds bachelor degree in commerce. He is a practicing advocate, very rare CA and practicing advocate. I think something very unique, not easily found. And Mr. Ayush has been providing services to financial lender, corporate under IBC, advising RP and other IP entity representing RPs before NCLT, NCLAT, and other legal as a legal counsel, and represented in the various complex issue, including resolution plan, forensic applications, and as a state RP of over 1,000 matters. He has been represented RP in leading and continuous matters involving big matters. And he is a regular speaker at Indian Institute, Insolvency Professional of ICAI, various study circle and webinars. Welcome, Mr. Ayush. And today we have presenter, Mr. Sushant. He is also the part of IP entity. Sushant Jadhav. He is CS and also handling compliance of IP entity Mehta Mehta, Insolvency Restructuring LLP. Welcome, Sushant. And I will request Mr. Ayush to say a few words if he wants to say, and then we can, Mr. Sushant, you can start the presentation. Over to Mr.
Thank you. We appreciate and thank you so much, Ms. Mehta, for this opportunity. We look forward for this, and it's been an honor to be present today. We appreciate the opportunity, and we are more than happy to, tag along. It's been, probably for us, it's the first joint webinar in that sense, and looking forward for many more. Thank you for the introduction. I'll request Mr. Jadhav to proceed with the presentation, and we'll take it forward. Thank you, sir.
Thank you. So I'll just share the screen so we can just have a look at the present. Yeah, I hope everyone can see this screen over here.
No, not Sushant, not yet.
1 second. Yeah.
And now.
All right. 1 second. You guys can see this screen, right?
Yes, it's visible now. Yeah, this is slide.
Okay. Sure. All right. So yeah, good evening, everyone. Today we are discussing some important judgments under IBC and some disciplinary orders passed by the IBBF. So the first case what we have here is order passed by the NCLT Kolkata bench in the matter of Neeraj Agarwal versus Indian Ocean Group Pte. Limited. Here the facts of the case is an application has been filed by the chairman of the monetary committee in the interest of the financial creditors. The successful resolution applicant failed to deposit the upfront payment as mentioned in the approved resolution plan. And the honorable bench had observed that there is no provision for recommencement of the CRP of the corporate debtor. Therefore, no need for filing an application seeking directions for forfeiture of the performance security deposit from the adjudicating authority. The chairman of the monetary committee was directed to proceed in accordance with the terms of EOI. This is what the honorable bench observed in this present case, what we have. So
In fact,
should I move?
more
Yeah.
of probably a clarificatory order in that sense. And it just clarifies the position that there are certain aspects which are given in the code itself, which come into play automatically, and there are of course no requirements for specific directions or approaching the NCLT for every issue now and then. I think this was helpful in terms of clarifying a bit of procedural aspect. So rather
Yeah.
than proceed to the next one, I think that will be more. The next one is more interesting.
Yes, yes. So second, what we have is an enclate order in the matter of UV Asset Reconstruction Company Limited versus Electro Steel Castings Limited. Here we have Shrey, who is a financial creditor, and Electro Steel Steels Limited is a corporate debtor in this matter, and Electro Steel Castings Limited is a promoter company, is also a holding company of Electro Steel, which holds 34.40% shares. Here, so the facts of the matter are is a Shrey who has provided financial assistance to the corporate debtor to the tune of 500 rupees crore. And the promoter company entered into the deed of undertaking in the same year, in the same month, between the financial creditor and the corporate debtor. And as per the deed of undertaking, the promoter was an obligor, and in failure of the payments by the corporate debtor, promoter will infuse the funds. This was the deed under arrangement as per the deed of undertaking. And the promoter also entered into a supplementary agreement where the promoter mortgaged its land in the favor of Shrey. Later in 2017, application under Section 7 was filed by SBI against the corporate debtor, that is Electro Steel. In 2018, during the process, a resolution plan was submitted and approved, submitted by Vedanta Limited, which was approved. Shrey, as per the resolution plan, received an amount of 241.71 crores. Later in 2018, Shrey executed an assignment deed in favor of UV Asset Reconstruction Company Limited. On a UV Asset Reconstruction Company Limited filed a Section 7 application against ECL, that is the promoter company, in 2021. ECL claimed that the debt owned by the ECL, that is the corporate debtor, to Shrey was discharged due to the approved resolution plan. ECL, the adjudicating authority, rejected the application filed, stating that ECL, which is a promoter, was not a guarantor, and the corporate debtor's debt was extinguished due to the resolution plan. Here we have two questions which in the appeal, two questions which arise for consideration. First one was whether the ECL is a guarantor to the Shrey for the financial facilities availed by corporate debtor from Shrey. So the honorable bench observed that the additional funds, in its order, they observed that the additional funds which were to be provided by the promoter by way of equity capital and unsecured loans or deposits, obligation was on the respondent to arrange the infusion of funds to ECL, that is to the corporate debtor. No obligation was undertaken by the promoter to discharge the liabilities accrued on the corporate debtor as per the financial covenants to Shrey. Sanction letters and the other information memorandum do not contemplate any corporate guarantee from the respondent. The second question which came up was whether approval of ECL's resolution plan, that is a corporate debtor's resolution plan by the adjudicating authority, led to the extinguishment of the entire debt of ECL, and no claim would lie against ECL as a guarantor third party surety in respect to the financial facilities. In regard to the second question, the honorable bench observed that after the approval of the resolution plan, entire debt of the corporate debtor against the financial creditor stand discharged, and approval of the resolution plan, financial creditor can have no further recourse against the corporate debtor. Law on extinguishment of claim against a personal guarantor and third party on approval of resolution plan has been settled by the Honorable Supreme Court in its judgment of Lalit Kumar Jain versus Union of India, where the Honorable Supreme Court stated that the approval of resolution plan does not ipso facto discharge a personal guarantor of the corporate debtor of her or his liability under the contract of guarantee. So what the resolution, what the conclusion of this, as per my understanding, it would be as whether debt of a personal guarantor or third party which arise out of a different contract shall automatically extinguish after the approval of resolution plan. This is what the enclave order had to say.
Just to add to this, now every participant would have already heard about this Lalit Kumar judgment. Now, of course, one clarity is very clear that just because a plan is approved, initial days we used to see all these applications coming in from the guarantors saying that based on the sections and the regulations, all the claims stand extinguished. and hence guarantors also stand discharged from their liabilities, and that is not the case, which is very well and detailedly argued in Lalit Kumar's judgment. In fact, what it said is that once it is held that the plan has been approved, which of course does not automatically discharge a guarantor, and any outstanding liability, for instance, most of these cases we've seen haircuts. So the lenders, it's always open for the lenders to reach out and take legal recourse against the guarantors for the balance recovery. So that is something which is again clarified, that just because the plan has been approved, the guarantors cannot be discharged from their liability, even in case of an assignment deed. And NCLAT, of course, upholds the same legal issue, which now we can say it's well settled in law in that sense.
All right. We'll move on to the third case. What we have. The third case we have is Sudhir Darode versus ICICI Bank Limited. Here, the facts of the matter is that the adjudicating authority has admitted a Section 7 application filed by ICICI Bank, who is a financial creditor, for admission of CRP against Darode Jog Realities Private Limited. Aggrieved by the impugned order, the present appeal was filed by the suspended directors of the corporate debtor. And then, the adjudicating on informed of the an appeal was filed by the suspended directors. On informed of the out of court settlement, the adjudicating authority permitted the financial creditor to withdraw Section 7 application. As per the settlement agreement, FC was to issue NOC to the corporate debtor. Financial creditor rather filed a restoration application to restore the petition filed under Section 7, as the settlement agreement did not mention of any form of NOC with regard to the mortgage properties. And then the honorable bench, in its order, considering the present facts, had observed that there are no areas have been committed by the adjudicating authority in allowing Section 7 application and in admitting the corporate debtor into the rigors of CRP. NCLAT do not find any reasons with the impugned order. Appeal thus fails and it is dismissed. This is what the NCLAT in its order observed.
So this was again, reinforcing the rights of the lenders, that once it is settled and there's any breach, now because of certain clauses or rather a defense being taken, that since there was no NOC issued, it doesn't really come to the rescue, because your settlement agreements needs to be properly drafted and worded. And it is also more of an eye opener, because every now and then as RPs, you will also see that once a petition has been withdrawn, the lenders after some time again reach out and say that, sir, this has already been breached, we may have to reinstate the petitions. Initially it was restoration, but now we've seen a trend that bench normally then of course permits the lenders to file a fresh CP rather than restoring the existing one which is already disposed of. So of course this is also something to be taken care of when you come across settlement agreements, and maybe before filing a 12A application you may have to highlight certain missing loops to the lenders, that probably they are missing on certain clauses, especially the right to restore petitions, because the right to file fresh petition arises out of this clause. Otherwise, we've seen other orders coming in for, especially for Section 9 matters, which says that a failure under settlement agreement is not considered as an operational debt. So that Section 9 settlements are a bigger issue rather than a Section 7. But nevertheless, this helps. It's more of an eye opener for the lenders, and just to be more careful when it comes to settling debts and the clauses there.
Okay. Yeah. So moving on to our next case, which is in PG Sales Corporation versus Lakshman Bhai, Mohan Bhai Vegad and others. The order has been passed by NCLT Ahmedabad bench. Here, what the facts are: the applicant is a successful bidder under e-auction held in 13th April 2023 for the sale of assets as on as-is basis and no recourse basis. As per the e-auction as the e-auction held, the facts of were, as the vacant possession is handed over, it means it was not occupied by any person at that time. After taking vacant possession from the liquidator, it is the duty of the purchaser to protect its properties, thus not fall within the ambit of the liquidation process. Yeah, there was also a security guard in the land which was taken over by the auctioneer, and the security guard then created certain problems, and he filed a case also in the doctrine of adverse possession. Here, I would just like to say that adverse possession is a legal principle that states if a tenant has occupied the property for 12 years or more and the owner fails to take any action against that, a tenant is granted ownership rights towards the property. Yeah, so the honorable bench also observed in its order that once the premises has been taken over by the auctioneer and there has been peaceful possession, it is not the duty of the liquidator after the possession process. It is the duty of the auctioneer to take care of it and to protect its properties. Therefore, it does not fall within the ambit of the liquidation process.
This is actually a very interesting and a peculiar situation that the Ahmedabad bench had to deal with. What we can, the learning that comes out of it is on twofold. One, once a bidder has taken over the possession, they have visited the site, they have done their due diligences, and as in this case, they had also documented that it has been handed over by the liquidator to the successful bidder in terms of its vacant and peaceful possession. Now, any issues thereafter cannot become a subject matter for the Honorable NCLT to deal with. This is where, in essence, the provisions or rather the jurisdiction of NCLT comes into picture in terms of section 60 bracket 5, which I'm sure even the participants would have heard of several judgments, more specifically the Gujarat Urja Supreme Court order, which is very clear. And it also states, I'll just quickly read out the relevant para of Gujarat Urja for benefit of all. That says, therefore, considering the text of section 60 bracket 5 code and the interpretation of similar provisions in other insolvency related matters, NCLT has jurisdiction to adjudicate disputes, but only which arises solely from and which relate to the insolvency of the corporate debtor, not civil disputes, not other disputes which were divorce of any, which is divorce of the insolvency resolution process. In the present case, the bench has rightly held that they were given vacant possession and any civil disputes arising thereafter, then appropriate measures should be taken. The bidders cannot come back to NCLT with such issues which is beyond their jurisdiction. Once a plan has been approved or once it is handed over as a going concern, it becomes a different forum altogether, and NCLT cannot venture into every civil dispute or every issue which requires specific performance in that sense. So one thing is clear, of course, that the window of approaching the NCLT under 60 bracket 5 is, though it can be said it is residual in nature and wide enough, but at the same time, it cannot venture into other forums or other laws which is beyond the jurisdiction. So this is something which we need to take care of. When the bidders come in and do their due diligences, they need to be aware of all these varies. Otherwise, we've seen applications coming in where they allege that the liquidator did not highlight the relevant facts, or if it's a resolution plan, the RP did not mention all of this in the information memorandum, so on and so forth. So a bit of a caution. We can also say it is more of a conduct of a buyer beware situation. It is, so that is something which the bidders in that sense have to take care of, and be wary of what matters NCLT can deal with and what they can't. So this is in essence dealing with the jurisdiction of NCLT for taking legal course.
Okay. All right. So moving on to our next order. Here we have a State Bank of India versus Mr. Ramakant Gupta, who is a liquidator. The facts of the case are the application was filed under section 65, read with rule 11 and 32 of the NCLT, seeking to replace the liquidator of the corporate debtor, which is Sujyot Infrastructure Private Limited. The SBI in the application requested that the present liquidator is not empaneled with the SBI as a liquidator and hence requested to replace the liquidator who is empaneled with the SBI. It is stated that such agenda for replacement of liquidator was discussed in the second meeting of the SCC, whereby it was resolved to replace the Ramakant Gupta, the present respondent, as a liquidator and to appoint a new liquidator, Sachin Bhat, as a liquidator in place of Mr. Gupta. Hence, the application was filed. The Honorable Bench observed that a liquidator is not on the panel of the bank is not a valid and reasonable reason to remove, replace, and the wisdom right for change of the liquidator is not available to the SCC, that is the Stakeholder Consultation Committee, in the liquidation process. Stakeholder Consultation Committee has to record specific reasons for the replacement of the liquidator. It cannot just replace the liquidator considering the only fact that it is not empaneled on the bank's panel.
Now, this is also something which I believe quite a few participants might have faced in their professional, job profile, where certain lenders especially in case where a particular lender has majority share voting. Typically, they do replace on the pretext that no, you have not been empaneled or your empanelment was still under process. So as per our internal policies, we need RPs who are empaneled with us. Now, uh, unlike statutory auditors or unlike the other auditors where there are specific empanelments, for an RP, the moment is an IBBI is there on the panel, all RPs are treated at par, and lenders cannot differentiate or rather can't replace an RP just based on a empanelment issue. So this is something which, of course, we can also be wary, and probably, at the time of discussions, certainly we can put it across to these lenders, okay, sir, if this is the reason why you are replacing, probably may not be the right legal way to deal with. Now we understand, at the end of the day, we are dealing with lenders day in and day out. So no IP per se would want to agitate on it, but this is a very good order in that sense to clarify that not everything falls under their commercial wisdom, even if they have the 66% voting share. So a good order to keep it handy in case, if we feel the need to discuss this with the lenders, because empanelment is not a prerequisite for appointing an RP or a liquidator in that sense.
Right. Yeah. Moving on to our next case is Acre 81 Trust and others versus Pawan Kumar Goel, IRP and others. It's an enclave order. The facts of the cases are after admission of the application filed under Section 9 of the Code, IRP conducted the first meeting of COC and informed the members of the COC that the office of the corporate data was closed for more than 1 year, and all the directors of the corporate data had resigned before the commencement of the CRP. The last audited financial statements of the corporate data filed with the ROC for the year ended March 2017, and the secured financial creditors of the corporate data had initiated enforcement action against Sarfezi and taken over the possession of the project assets. In the fifth meeting of the COC, 88.48% of the COC members, including the financial creditors in class, voted in favor of the liquidation of the corporate data. The IRP filed an application for the liquidation of the corporate data accordingly. The decision of the adjudicating authority, the bench observed that in the order, the adjudicating authority had observed that until EOI, that is expression of interest in Form G, is published, there is no mechanism under the regime of IBC to discover prospective applicants for a corporate data. And without publication of Form G, COC could not have been in a position to formulate an opinion that there were no prospective buyers available for the CD. It was concluded that without taking any steps for seeking resolution of the corporate data, the COC has acted in the contrary to the scheme of IBC. The bench also observed that the liquidator had malified intentions before filing the application of the liquidation of COC. Then it was stated that there is no dispute that the COC took a decision for liquidation of the corporate data after holding 5 meetings and by a voting share of 88.48%. Though there is an error in the approach of the adjudicating authority for the purpose of taking a decision regarding the liquidation of the CD. And the COC has to complete, and it also stated that the COC has to complete all the steps regarding resolution of the CD because it would be against the spirit of Section 33.2. An explanation appended to it wherein the legislation has used the word anytime twice, that is firstly in Section 33.2 and secondly in the explanation of the Section 33.2 of the Code. And the COC has the jurisdiction to pass the order of liquidation by the CD, approving it by not less than 66 of the voting share, but it should be before the confirmation of the resolution plan. Hence, the present appeal is allowed and the impugned order is set aside without any order as to cost. That is what the anklet observed in this order.
In fact, this is also a good judgment in terms of clarifying the position. Now, many a times we've come across that, especially in trading entities and such other corporate debtors, where there are not much of assets. In fact, even the offices are rental premises, and nothing really is there in the entity for any applicant to come forward. So COC at times do take a call that instead of incurring the CRP cost and getting into the process, they can simply push it to a liquidation, or rather we've also seen cases where they straight go for dissolution concerning. So the NCLAT has clarified that the statute itself provides 33.2. What the NCLAT said is that the regulation, or rather the section itself said that where the RP at any time during the CRP process, but before the confirmation of a resolution plan, intimates the adjudicating authority of a decision of the COC to liquidate the corporate data, the adjudicating authority shall pass a liquidation order. So the statute is very clear and also gives the benefit of taking a commercial call to the COC members where they do not foresee anything positive arising out of it, or rather maximizing value. They may just land up spending some CRP cost. So it is well within their powers to straight skip the process, get into liquidation. And in some cases, we've also seen that straight dissolutions are also being preferred at the present time, considering the asset value of the company. So this is something which is handy in cases where there are not much of assets in the corporate data. Now, probably this also helps the RP for two reasons. One, when there are no assets, even professionally, the COC usually is reluctant to release the fees because they feel that nothing is going to come out of it. RPs, liquidators in that sense cannot resign by themselves. So maybe where there is no asset value, there are no fixed assets, then probably this is something which even as an RP we can propose to the COC members after the first couple of meetings, and after we have sufficient data to show that nothing really would pan out of this process rather than spending some more time. So this is something which can be highlighted to the COC members, and sometimes they do appreciate in that sense that no, this was a fair suggestion as well, that if they do not see value, it is better to move towards liquidation.
All right. So moving on to our next case is an NCLT order in the matter of Vishram Narayan Panspur RP versus the COC of Blue Frog Media Private Limited. Here the facts are the corporate data. Blue Frog Media Private Limited had filed an application under Section 10 of the code. A resolution plan was submitted by Mr. Mahesh Mathai, an ex-director of the corporate data, who was also one of the directors in the company who would resigned in 2018. COC on 2021 by 91.86 votes share has approved the resolution plan submitted by the successful resolution applicant. Resolution professional accordingly then filed an application under Section 36 of the code seeking approval of the resolution plan. The adjudicating authority by an impugned order reported holding in rejected I 2828 of 2021 holding that the respondent number 2, that is successful resolution applicant, is not eligible under Section 29A. The order states that not that the case that any of the clause A to G are attracted on the successful resolution applicant, the mere fact that the successful resolution applicant was a promoter and director shall not make him ineligible to submit a resolution plan. This is like the gist of the order which was passed by the honorable bench.
So they allowed past promoter to be.
Yes.
Yes, great.
Yeah. So I'll move on to my next case. Yeah. It's an order passed by the Honorable High Court of Bombay in the matter of Anthony Raphael Kalarakal versus NCLT Mumbai bench. Okay. The facts of the case that the petitioner approached the High Court challenging the order passed by the Honorable NCLT Mumbai bench jurisdiction and in violation of the principles of natural justice and also in a violation of Section 91 of the Maharashtra Cooperative Societies Act. It stated that there are two remedies available, that is under Section 61 to file an appeal before NCLAT, and the second remedy available was under Section 62 to prefer an appeal if it is aggrieved by the order of the appellate tribunal before the Honorable Supreme Court on the question of law. Hence, the petition was dismissed on the ground of availability of the alternate remedy in law.
So sometimes we do see these situations where once a law has prescribed a particular remedy, and if that sequence is jumped and they move towards a high court, we've seen orders coming through that whenever you have an alternate remedy, the high court always sends them back, that when you have an option to go to NCLAT, kindly exercise that. Failing which, in any case, you still have a window to go to the Supreme Court. So this is one such again order which highlights the need to stick to a particular forum and not jump between the two forums, or rather what we call it as forum shopping. It's better to follow the vertical and the legal recourses that is available to any aggrieved party. So this highlights the need to follow due course in that sense, and not approach the Honorable High Court in every now and then under an Article 226 writ. So something, of course, which highlights the need to follow the process and respect the code, I would say so.
Right, that will save the time of High Court also, it is.
Absolutely, certainly.
Yeah.
We move on to our next case. which is Sawan Godiwala versus IBBI. Here in the present case, the petitioner is an IP insolvency professional. It is stated that the petitioner has contravened various provisions of the code and therefore disciplinary proceedings were initiated.
Now
A
we are
draft.
starting disciplinary, Sushant.
No. This is still there in the order.
Okay,
It's a
okay,
Delhi.
okay, High Court, sir, yeah.
Yeah. A petitioner has contravened various provisions of the code. Disciplinary proceedings therefore were initiated. Draft inspection report was prepared and submitted to the petitioner. Then a show cause notice in 2022 was issued to the petitioner, which the petitioner replied to the notice. Ultimately, an order was passed by the IBBI. The show cause notice does not, it is stated that the show cause notice does not contain the extracts of the relevant provisions from the report of the investigation. And admittedly, the report of inspection was also not given to the petitioner. The petitioner challenged the order on the grounds that the that the regulation mandates that the show cause notice shall enclose the copies of the relevant documents and extracts of the relevant portions from the report of the investigations or inspection on other records. And then the court, in its order, observed that it set aside the IBBI disciplinary committee's order and remanded back the matter on the grounds that show cause notice issued to the IP does not contain the extracts of the relevant portions from the investigation report.
Now, yet again, we do see the need, or rather the legal enforcement of the fact that there is a principle of natural justice involved in every proceeding, be it IBBI, be it any other civil or criminal process. This is one such order again, where apparently when you are passing an adverse order, it is the requirement under law to provide the entire supporting documents to such respondent or the defendant in that sense, so that they are aware of what is being placed against them before a court of law. Sometimes we observe similar position, especially if we talk about an avoidance transaction application, for instance. Now, in some of the applications, we've seen that only extracts of a forensic audit has been given, and then we have applications filed under section 43 to 66 as the case may be. There have also been instances where respondents come and say that you can't just give me an extract, you have to submit the entire report, even if the other 100 pages do not relate to that transaction or to that respondent. Again, the need of natural justice arises in several cases. So whenever we have certain findings, especially when we talk about avoidance transaction applications, it is essential to highlight these facts and submit the entire report, which curtails certain litigation and also helps clarify the position before the bench. So that, of course, is also part of a natural justice scenario, and it has been universally accepted. And it, otherwise failing which, it's a good defense for anyone to send back an order, and they'll effectively restart the litigation.
Yeah, Sushant, go ahead.
We'll move on to the next case. Here, it's an order passed by the Gujarat High Court in the matter of Amit Dinesh Chandra Patel versus Reserve Bank of India. The facts are the petitioners are aggrieved by the decision of the respondent banks taken in the joint lenders meeting, declaring the account of the Syntex Industries Limited as fraud. Contention is raised that the petitioners that while taking the decision, the petitioners have not been offered any opportunity to deal with the forensic audit report or the supplementary forensic audit report, which otherwise is a mandate issued by the Apex Court in the recent judgment in the case of SBI and others versus Rajesh Agrawal and others. Pertinently, except sharing the observations of the draft forensic audit report with the petitioners, neither the copy of the forensic audit report nor supplementary forensic audit report was provided to the petitioner. The bench had taken a decision. The High Court, these are the decisions in the given. The clause 8.94 provides for decision to classify any standard account or NPA account as RFA or fraud at the individual level, and the responsibility of the bank to report the RA or fraud status of the account on the CRISIL platform so that other banks are alerted. And clause 8.9.5 envisage completion of the forensic audit within a stipulated period. It also provides that in case the decision is to classify the account as a fraud, the RFA status shall be changed to fraud in all the banks and to report to RBI and on the CRISIL platform within a stipulated period. The High Court holds that lenders bank should provide an opportunity to a borrower by furnishing a copy of the audit report and allow the borrower a reasonable opportunity to submit a representation before classifying the account as fraud. And therefore, the petitioner stands partly allowed. And
Similar line, opportunity of being heard and rule of equity and justice.
Yes, yes.
That's right.
Yeah. Yes, Shashank.
So now we'll move on to the orders passed by the disciplinary committee.
Yeah, we are on the right track then. Good.
Yeah. So first we have a show cause notice issued by the to the IP and so there are contraventions. First contravention is a failure to protect and preserve the assets of the corporate data. Allegations are that the post admission of the corporate data into CRP, the suspended management of the CD executed an apartment buyer's agreement. The IP did not take any actions for reversing the transaction as the same was not a valid transaction for the reason that the suspended management did not have the power after initiation of CRP to enter into any transaction or agreement on behalf of the CD. Submissions by the IP were the IP submitted that the two checks were received as initial booking amount on 2020. After receiving the initial booking amount, the builder buyer agreement had to be delivered upon the demand and availability of the home buyer. The agreement was signed by an authorized signatory from the marketing department of the company under the normal business activity of the corporate data at a prevailing market price. When the CRP has already been set aside by the Honorable NCLAT by order dated 22nd August 2022, the IRP of the CD is being dragged by filing a complaint by before the board, and that too by the person who had already settled this dispute with the CD and got his money back. A declaration to that effect has already been given to withdraw all the matters. The DC accepts the submissions of the IP. The second contravention alleged are the IBBI provides that the IP shall make a public announcement immediately on his appointment as IRP and publish the same on the website of the CD. However, here the IP did publish the announcement in the newspaper but failed to publish it on the website. The IP made submissions stating that the CD did not have any website of its own and it did not have the prerogative to use the website of the group. Therefore, public announcement was made only on the BBI's website. In addition to this, he also published it in the English and a vernacular newspaper. Analysis was, it was found that there's only one website of the group companies. In that case, the IP should have published on the group website, hence the IP failed to comply with the provisions of the IBC. The IBBI passed an order saying that the DC had warned the conduct of the IP and to be extremely careful while carrying out the assignments under the code. It was just
So
a
it
warning.
means that if there is a group website, then IP should write to the group company or whosoever is handling and mention that this should be there since there is no separate website. And if the action is not taken, then you can take it that same will be taken as non-cooperation and that can be that kind of at least action. So this is the learning we can see. Okay.
Yeah.
That's right.
Moving on. Next note is the first contravention is the RP authorized former directors to represent the corporate data and engage advocate. The IP in his COC informed that a meeting with the former directors was held and authorized them to represent the corporate data and also allow the continuation of the engagement of their advocates for the ongoing litigation. The same has been duly recorded in the COC minutes. IP submitted that prior to the commencement of the CRP of the corporate data, there were several litigations initiated by the suspended management against its sundry dators. The IP in its meeting with the suspended management submitted that such allegations are not maintainable pursuant to the CRP order. It submitted that if a replies to such applications are not filed, the matter would be dismissed. Under the given situation, it was difficult for the IP to understand the intricacies of each case and prepare applications for impleading RP at a shorter notice. It was also found that there was no bank balance in the corporate debtors account to meet the legal expenses to hire the advocates and do other actions. The COC was duly intimated by the RP of the authorization given to the director of the suspended management to continue the process of the ongoing litigation. The COC took note of the said authorization and did not raise any objections in the meeting regarding the same. The analysis were on bare perusal of the records given by the IP. In none of the litigation matters, there were requirement for filing of reply. IP allowed the directors of the suspended management to appear more than once in the hearing of such litigations. Hence, the submissions of IP does not match with the factual position submitted by him and amounts to misrepresentation before the DC. The information further available on the website shows that the IP filed an application under Section 19(2) for non-cooperation by the suspended management 10 months from the resolution passed by the corporate data. Further, that even after decision to file an application under Section 92 of the code, IP did not make any efforts to represent the corporate data. And there's the IBB at the DC suspends the registration of an insolvency professional for a period of 1 year.
Just one specific thing that needs to be highlighted is that whenever an order is passed, of course, an IP is exposed to an entire corporate debtor suddenly without any intimations. We don't know about the litigation history or the scenarios. Sometimes while discussing with the COC members or going through certain documentations, if it is found that the company has been made a party in some issue, say for example at a small causes court, or there is some other arbitration going on which is beyond the NCLT's jurisdiction. So it is imperative for the RP to immediately have its representation to those respective authorities, be it the income tax appeals, be it GST, be it any other civil or criminal proceedings. In fact, even as much as a Section 138 proceeding is concerned, so that the jurisdictionally the respective courts are aware that the corporate is under insolvency, the RP's attendance in that sense and the occurrences have been duly marked in the orders. And in most of the cases, it is also possible that once you represent, you can always take forward Section 14 and have the company discharge or recuse from those proceedings. And almost all civil courts now are aware of IBC, be it small causes court, be it sessions court. They appreciate the law and they do also understand the RP's position. So in that sense, it also records the right and factual aspect, and plus also absolves IPs from such complaints under IBBI scanner, where RP is unable to, or rather after having knowledge, that is a more of a red flag, that once you have knowledge of an ongoing litigation, your representation or a correct representation is required. I understand sometimes there are issues in terms of appointing advocates and lawyers due to the crunch in the financial crunch, but it is imperative that RP immediately highlights this in one of the COC meetings, has it documented in the minutes itself that this was discussed, and the need for appointing legal counsels or advocates were highlighted to the COC members and they have taken note of the same. So in worst case situations, that minutes itself can come in very handy, and it comes to the rescue when some complaints are flashed, which is 6 months, a year down the lane. So these things are a little, self-check basis. It's important to keep track and keep highlighting it before the COC. And of course, 19.2 applications are something which are now taken up urgently by all RPs across the board in that sense. And any undue delay, we do hear from the managements every now and then, give us 15 days, we are traveling, someone is not well, wait for a month. But at some point, there should be a cutoff, and RP should file those applications. Let them come before the bench and seek time if they want to, in terms of sharing data. But of course, a delay like this, about a 10-month and odd, is not acceptable. And it only goes to show non-action on the part of the RP, which is professionally also not advised. And it doesn't really help RP's case to come on the defensive side when something could have been done very easily and much prior in time.
All right. Moving on to our next is a show cause notice issued in December 2023. The first contravention is lack of due diligence in verification of claim. The insolvency professional constituted COC with XYZ as its sole financial creditor. However, later, due to addition of a new FC, the COC was reconstituted, because of which the voting share of the first FC dropped from 100% to 25%. Further, the IP relied on the documents for verification of claim of the new secured financial creditor, which were questionable in its authenticity, as the balance sheets of the year from financial year 16-17, 17-18, and 18-19 got prepared in 2020 by the IP during the continuation of the CRP after the receipt of the said claim. It is further noted that the balance sheet of financial year 15-16, based on which the aforesaid claim was admitted, and subsequent balance sheets prepared thereafter, did not contain the seal of the chartered accountant. On admission of such claim on new financial creditor, an application was filed by the earlier financial creditor questioning the admission of such claim, which was dismissed by NCLT. Thereafter, an appeal was filed in respect of the same, wherein the Honorable NCLAT held that the RP did not exercise due care and conduct proper scrutiny of documents pertaining to the claim, wherein it was observed that the claim was barred by limitation and hence was not liable to be admitted. Submissions by the IP were that because of some unfortunate event, he was not able to properly represent his case before NCLAT. due to which the order passed by the Honorable N-Cled suffers factual errors. The order was passed on the basis of certain written notes which were not supported with an affidavit. The IP was not allowed by the Honorable N-Cled to submit an additional affidavit to bring on record few other matters in support of the IP's contentions. Further, in Swiss Ribbons versus Union of India, it was held that the RP has no adjudicatory powers and it is only vested with the limited powers to verify claims. And upon undertaking such exercise, the RP had admitted claim of the new financial creditor. However, after such order was passed by the Honorable N-Cled, the IP removed the new financial creditor from the COC. The analysis with the DC committee held that the IP should have been more careful in dealing with the claims. The disciplinary committee disposed the show cause notice with the caution to the IP to be more careful and vigilant while handling assignments.
Now, this is yet again a situation where RPs are faced with incoming claims right up till the plan has been put to vote, and of course that results in the change in the voting shares. Now, taking references, there's always a dilemma. On one side you have Swiss Ribbon, which says that you cannot have adjudicating power, and on the other side you have these facts and figures, especially the balance sheets. Now, most of the cases, balance sheets are not uploaded in the ROC for quite a few years prior to the insolvency commencement. And in case if the RP is lucky, promoters may be willing to submit the tally data up to the insolvency commencement, which again is not going to be an audited document. So a question always arises on whether to admit a claim just by looking at the Form C being received from some claimant, or the RP has that power to look into the balance sheet and question the admission itself, which in my view, it is to be done. It is not exactly that you are adjudicating a claim, you are not getting into the merits, you are plain vanilla comparing it with two sets of documents. One is the Form C given by a claimant, which has to be either verified by bank statement, which again, there is a good possibility that you will not have those sufficient bank statements on record to show whether the payments, there was any disbursement or no. And the other is, of course, the balance sheets. Now, having said that, there is always a requirement that the RPs need to cross-question the claimant, send out these details and ask them to reconcile and prove or make out their own case. If you do not have a balance sheet of bank statement of the corporate debtor, the one who's paid money will obviously have his own bank statement. So things like that, he needs to show his disbursements. They need to show that there was an actual genuine transaction. And of course, coming back to the need and the requirement of having it documented in the minutes. There's also a need to update the list of creditors before the honorable bench. So that is also something which RPs can take forward in terms of a caution, that the bench is also aware that there was this kind of a claim which has come in, which has substantially dropped the existing claim of a secured financial creditor from 100 to 25%. And this is the red flags that needs to be highlighted. Now, this is something which should come proactively rather than some other creditor filing an application against the RP before the bench. So that helps. Again, minutes of the meeting are essential while recording all of this. And the reportings and filings with the IBBI in terms of your portal updates to just to show that the claims have been updated, so that it is publicly available as well. So certain, I would say, housekeeping checks, but not all action is to be treated as if you have no powers. You do have sufficient powers, and RP is not just a rubber stamp. So we need to be a little more diligent in terms of questioning as well. Questioning is also part of your verification of claims. So this is something which we can take care of.
Mr. Ayush,
Yes.
your view, I want to, on one of the kind of situation, many times what happened, that operational creditors filed a claim with supporting, and they give, so we ask, they will file the claim, but there will be no entry in the company's accounts. We check the ledger of the company, maximum. Then the operational creditor give the client their ledger and supporting documents. Now, in this situation, if there are good, reasonable supporting documents and ledger and accounting by operational creditor, but there is no reference or anything in CD, whether the RP should accept this kind of claim or what it should be. What is your view in this kind of situation?
So in my view and based on the experiences, what happens is once an operational creditor, two first red flags that needs to be checked. One, whether he's a related party to the CD or no, because that is something which raises a red flag immediately. Second, if he is not a related party, they are genuine third-party businessmen, considering their business profile and the company's business profile, that there is a good possibility that there would have been transactions. Now, as an RP, you may not have the details because the balance sheet typically only shows an amount of trade payables. So that would be hundreds of crores of rupees dealing with thousands of payables. Then you will not have groupings, or you may not have the tally data to verify independent ledgers. But prima facie, once you have sufficient data, I believe that needs to be admitted. One question, however, still arises that whether RP should get into the fact that it is time-barred claim or not, and whether that would tantamount it to be adjudicating a claim. Now, there is an NCLAT order in the case of PM cold storage, which says that RP needs to also consider the limitation issue. So there have been instances where you have to reject the claim. So for example, if a CRP started in 2020, it is barred by limitation. And the second red flag that arises is why for 7 has kept without any civil proceedings or without any legal notices being issued. So a few facts and figures, but if it falls within, if the reasonable documents are on record, in my view, the claims should be accepted, and the process can then proceed further. We do not, at the same time, we don't even want unnecessary litigation to creep in to the system.
Yeah, so because see, maximum the RP can, Mr. Gagan, I will give you the opportunity, 1 minute. But the RP will say RCD that this is the claim received and what is your view and all that. If there is no comment or no sufficient reasoning not to reject, then I think it can be accepted as such with the knowledge of of course, committee and all, right?
Certainly.
And yes, very important point you have mentioned that limitation period we have to check and we have to say that it should not be beyond the limitation period.
Certainly.
Yeah, Mr. Gagan, you can unmute. IT department, just check Mr. Gagan is unmuted and can speak.
Am I audible, ma'am?
Yeah, you are audible.
Right now, ma'am, my question is how to differentiate verification, collision, and adjudication. Right now, this disciplinary case relates to, I guess, verification mainly. And what about the GST component, ma'am? Right now, the IBBI regulations is introduced to check GST while verification of the claim.
So see, Mr. Karan, there are two things you have a right for, you've pointed out a right issue, and that's more of a practical issue faced in every entity. See, as far as the GST component is concerned, one, you need to have the credentials to verify, which again, in most cases, it is difficult because unless there's cooperation from the management to give you those login details, or rather to assist you, at least with the OTP so that you can have your password. So that is a bit of a uphill task to gather. As far as the claims are concerned, if the creditor is able to satisfy that no, there was an invoice raised, there were transactions that have happened genuinely, he may or may not have balance confirmations, unfortunately, because if the balance sheets are not finalized by the corporate debtor, the creditor may not have a balance confirmation from the CD per se. But again, coming to the fact that if they are able to satisfy you based on certain documents and invoices and a running account, for instance, now most of the entities you would see that if it's a regular vendor or a supplier or a service provider, they would have had at least about 6 months, a year, couple of years dealings with the corporate debtor prior to insolvency commencement. That also helps you understand the trend. Now, had it been a case where you suddenly have 10 claims with one transaction alone, or there are 10 creditors who've come in with one invoice out of the blue and you have no backtrack, then there is a possibility that you may reject it due to lack of evidences and lack of supportings. But if it is a running entity, you see the ledgers. The ledger shows transactions for a period of a year and a half, and also specifically that these are not journal entries. They are invoices and there are payments received from the corporator to such vendors that I believe would sufficiently justify admitting their claims. Now, GST component is a different issue which you may not be able to verify, but then non-availability of a GST return or verification, that sole document cannot be a reason for rejection. When you have other ledgers, you have invoices and things and so on and so forth. So probably we'll have to be a more pragmatic. And once you are satisfied, out of 10 documents, you have 6 which sufficiently justifies, it is good enough to admit a claim.
Okay.
Okay.
Yes, go ahead.
Yeah.
Thank you, Mr. Gagan. I hope you have been answered. Yes,
All right. Yeah. So moving to on to our next, the first contravention is the issue in the auction under the liquidation process. IBBA has prescribed a particular manner in which the sale of assets under liquidation is to be undertaken by the liquidator. If required, IP can conduct multiple rounds of auction to maximize the realization from the sale of the assets and to promote the best interests of the creditors. An auction was conducted wherein a vehicle was sold to one Mr. XYZ. It was then noticed that another e-auction was conducted wherein the same vehicle was again listed even though they were already sold and a part payment for the same were received. However, after receiving EMD from certain buyers, the IP informed that the said e-auction has been cancelled. This shows negligence on the part of the IP. Submissions by the IP were the IP submitted that even though the e-auction was cancelled and for the particular vehicle, however, e-auction was still carried on for the land and building. Hence, accordingly to IP, no harm was caused to the entire process of liquidation as there was no delay or even the commercial viability of the liquidation process was affected. On analyzing the records, various emails were sent to the IP asking clarifications for reason to return the EMD and cancellations of a e-auction. Neither did the IP take any efforts to make the stakeholders be aware of such cancellations. Second contravention is reduction in the reserve price beyond permissible limit. The IP in this case had conducted two e-auctions for a vehicle wherein the reserve price in the second e-auction had dropped to 33.3% against the permissible limit of 25%. IP submitted that there was no reduction in the reserve price as per the statutory provisions of the code. The auction value of the assets were made at a price that was considerably and substantially higher than the liquidation value as per the liquidation regulations. The IP sold vehicles at a price much above the liquidation value as valued under the liquidation process. Hence, a successful attempt was made to sell the assets at a value higher than the liquidation value for the maximization of value to all the stakeholders. It was then analyzed that it is evident that there was a clear reduction of 33.3% in the reserve price of the vehicles auctioned. Hence, the point submitted by the IP that the reduction was still higher than the liquidation amount was not accepted by the DC. Third contravention is non-circulation of the minutes of the first meeting of the COC. Allegations are the IP is bound to circulate the minutes of the first COC within 48 hours to all the members of the COC. However, even after several reminders from the sole financial creditor, the IP failed to do so. The sole financial creditor had filed then an application for replacement of the RP. However, NCLT ordered the IP to circulate the said minutes within 2 weeks of the order. It was noted that the IP had provided the said minutes with a delay of 6 days. In the matter of another corporate data, the IP had again failed to circulate the minutes within 48 hours. On perusal, there were 4 emails sent from the financial creditor requesting the minutes of the first COC. However, the IP sent the same by speed post with a delay of 4 months. In the said minutes in the first COC, it was clear that it was discussed to replace the RP. Hence, it seems that the IP had with malafide intentions delayed to share the minutes. Submissions made by the IP were the IP submitted that the IFC failed to cooperate with the IP, also that the fees were not paid. IP was in a ICU and which made it difficult for him to conduct the CRP. The IP was also about to file an application for non-cooperation by the suspended managements and the financial creditor. The DC analyzed that there was a clear delay of 4 months in circulating the minutes, especially when it was resolved to replace the IRP. Also, due to non-payments of the fees, it was clear that the IP had a motive to intentionally delay the whole process. The DSP suspended the registration of the IP for a period of 2 years.
Again, this is one typical situation. Of course, there can't be an excuse in sending a COC minutes 6 days later or 4 months later, rather. So, certain things, certain basic checks are required. If for whatever unforeseen reason, if the IP is not able to attend office, then immediately at least someone from his office should indicate the financial creditors through an email and protect its own interest. That for whatever reason there is a bit of a delay in terms of ill health or a bereavement in the family, but it is not justified if a minute is sent 4 months down the line, especially when there is a agenda of replacing the RP. So these are the things which are inexcusable, and probably I would say IBB has rightly also suspended in that sense the registration, because certain basic professionalism is expected, and these timelines have to be sacrosanct. I can understand a 48 hour may go to 48 hours may go to 72 hours, but something like this is inexcusable, and I would say rather you can't even explain with any genuine reason for these things. So just a few red flags, and of course by now all of us are aware of this law. I don't think anybody now pushes the minutes beyond the 48 hour requirement. In fact, we've seen that the minutes are also sent out within 24 hours because the agenda is already known, the discussions happen. So almost all RPs are now in fact they're drafting the minutes real time and sending it out in less than 24 hours.
I think, Sushant, that's end of your PPT?
Yes, Doctor.
Yeah, I think so. So thanks, that was the total presentation of today's topic on the recent judgment. Any participants who wants to, Ms. Sushant, there is still cases? I think, Sushant?
I will do just one last one, but it's on the similar issue. No difficulty.
I lost you guys for a few seconds now. I'll
Sure.
Okay, yeah, next.
We'll move on then.
Yeah, please.
Yeah.
Yeah.
Slide 5.
Then non-cooperation. The first contravention is non-cooperation with the inspecting authorities in the conduct of investigation and non-submission of records to the board. Allegations that the investigation notice was issued to the IP in respect to the corporate debtors, to which the IP did not submit any reply, even after spending 2 reminder emails requesting to IP to submit few documents. The IA was constrained to file the investigation reports as 4 months had already elapsed since the notice was served upon him. In the matter of another 2 corporate cases, another IA had issued a notice along with reminder emails. However, again, no reply was given by the IP to the notice as well. It is evident that the IP failed to submit replies within prescribed timeline and did not cooperate with the IA to carry out inspection. The IP has failed to file all the relevant files on the IBBI portal as mentioned in the regulation. Submissions made by the IP were that the IP did not provide any reply to the notices of investigations and show cause notices issued thereafter based on the reports submitted by the respective IP. The basis of the material available on record. That the IP did not reply to the notices sent to him by different combination of non-filing of the CRP forms and non-cooperation with the IA by the IP is seen as a deliberate dereliction of duties with otherwise any IP is. Hence, the DC upholds the above contravention alleged in. Second contravention is non-conduct of the CRP proceedings. It is observed that the subsequent to initiation of the CRP of the corporate data, the IP made a public announcement and invited claim from the creditors of the corporate data. Meanwhile, an interlocutory application was also filed initiation of the group insolvency of the corporate data and its parent company by consolidating 2 separate CRPs of these 2 entities. The said consolidation petition is yet to be decided. Further, no steps were taken by the IP to conduct the CRP of the corporate data responsive to the creditors submitting the claim. The analysis by the DC notes that the IP supplied any reply to the complaints received against him in CRP of the corporate data, which was investigated by the investigating authority. The IP has not constituted COC and not conducted any meeting of the COC. He has also not replied to the claims filed by the creditors and also not been appeared. Gives an order stating that the repeated conscience not any reasons for being non-responsive to the communications of the board and its continuous absence from the proceedings as observed by the adjudicating authority clearly demonstrate that the IP is neither keen nor professionally fit to pursue assignments under the code. The DC has cancelled the registration of the insolvency professional.
Oh,
So yet again a very
very, straightway
blatant,
cancellation of claim. Oh my God.
blatant unprofessionalism, I may say so. So these things are inexcusable, not defendable. So of course, and being a regular practitioners, we are all wary of the law and also the obligations and our, to the reporting entity, especially with IBBI. So some things, it's more of a housekeeping. It can't be just left blatantly this way. And probably, if I may say so, probably a a factual scenario where instead of suspension, they have directly gone for cancellation of the registration itself.
Yeah, that was the thing.
A very extreme step that has been taken, but looks at the facts were called for it.
That's all, Sushant?
Yes, yes, that was the last slide for the presentation.
Okay. Thanks,
Thank
Sushant.
you, Sushant, for this exhaustive slide and the efforts and timely covering all the PPTs.
Yeah. Yeah.
Thank you. Thank you.
Everyone, this, entire presentation is covered, recorded, and it will be uploaded on YouTube, our YouTube channel. Everyone can go through the same at your convenience. Thanks the participants. Thanks everyone. Thanks Ayush for giving all your comments and expert suggestions and reviews and answering the questions and solving queries. Thanks for your time and understanding. Thanks all the participants for your support. We will have it the next webinar next month. We'll declare the date and tell you. It will be always generally at the end and at the last week of the month. Thanks everyone. Thanks Ayush, if you have few words to. Yeah, thanks.
We appreciate this opportunity, Ms. Mehta, and it's been an honor and pleasure to be participant here. Looking forward for many more conferences and appreciate the opportunity. Thank you, participants. Thank you for a patient and good attendance, if I may say so. So thank you so much for this. Appreciate it.
Thanks.
Thank you, Sushant. What's on the slide?
Thank you.
Thank you everyone. Thank you.